court has declared lockdown alert level 3 and 4 regulations unconstitutional and invalid. The court suspended the declaration of invalidity for 14 days, which means that level 3 regulations remain for now. The Cocktail Minister has been ordered to review, amend and republish regulations with due consideration of the Bill of Rights. Cabinet says it is still studying the judgment. To talk about this and other stories now, including this, British American Tobacco SA, Japan Tobacco International SA and 8 others with an interest in the industry on Monday, serving notice on the government that it's filing papers in the Cape Town High Court to have the continued ban on cigarette sales set aside. Law firm Webber Wentzel signaled that it was seeking urgent relief and gave the government until the end of the week to indicate if it planned to oppose the papers. It is asking the court to declare invalid and unconstitutional Section 45 of the regulations pertaining to level 3 of the COVID-19 gazetted by government last week. As I mentioned, we're joined now by senior legal journalist Karyn Maughan. A very good evening to you, Karyn, and thank you so much for speaking to us. Let me just start with this High Court finding declaring regulations level 3 and 4, level 3 and 4 as unconstitutional and invalid. Just to your mind, what do you think the greater implications are of this for the South African public?
Well, it's a very good question, but basically what happened was that Judge Norman Davis, in his ruling, in his conclusions, have essentially said that the imposition of regulations need to be shown to have a direct consequence for the kind of stopping of the spread of COVID infection. Now, we know there have been a lot of regulations that have been subject to quite strong debate, including around, what clothing people can and cannot wear. The cigarette litigation has brought forward a number of accusations that government is making decisions irrationally, not based on evidence. And the judge effectively saying in this matter, in a wider sense, that government has been imposing regulations on citizens in regards to these particular alert levels that aren't strictly speaking linked to stopping the spread of COVID infection. Now, within the public debate space, and I'm not sure whether these issues are substantively canvassed by the court, but for example, reopening in churches in contexts where you're not allowed to go and visit family members, not allowing the sale of cigarettes in circumstances where you allow the sale of alcohol, which, as we've seen from news reports today, and according to Chris Hani Baragwanath Hospital, has resulted in increased levels of trauma, which will then put pressure on the public health system. So essentially the conjecture here is that government is making decisions and imposing regulations, aka, the rotisserie chicken debate that we saw some time ago, without necessarily really linking them to stopping the spread of COVID, and without, properly engaging in a constitutional manner with people who are affected by those regulations in the first place.
I'll ask you this question. I mentioned the notice to government that the tobacco industry intends to challenge alert level 3, especially on the smoking ban. And the industry has argued that government has not illustrated enough that not only does smoking exacerbate one's health, especially in relation to COVID-19, but that it would encourage the spread of COVID-19. So would something like this also hold up against this? Now, we spoke to the lawyer that had taken the matter to court, of which we're talking about the finding, saying that it has nothing to do with the tobacco ban because it's a case that's still going to come before the courts. But I'm curious, to your mind, then, would this argument hold water, that some people are being forced to stop smoking, it's not of their own volition? Would that fail the rationality test we're talking about?
Well, that's a key pivotal question. And remember, there's 2 applications currently before the court. The one's been brought by the Free Trade Independent Tobacco Association of South Africa. That matter due for hearing in court next week before a full panel of judges. We know that government is attempting or has been attempting to delay the hearing of that case. And then a separate application brought by BAT, which really is about a constitutional challenge, saying that this ban on cigarettes has been actually completely unconstitutional and is unlawful. But at the heart of both of those applications, this question of rationality. And BAT and FETA have both raised in different ways these question marks about really, is there substantive evidence that smokers have a greater comorbidity risk than, for instance, diabetics? There's been a concrete amount of evidence gathered around obesity, diabetes. FETA raises this in this case, says, well, if you're going to ban cigarettes, for example, why are you not placing bans on the sale of fizzy drinks, on sugar, which would obviously have an implication for type 2 diabetics, who are far more on the data amenable to comorbidity with COVID. Also questions about the Minister Dlamini Zuma's conjecture, for example, that this ban will lead to smokers just stopping from smoking, where in fact the evidence that is being gathered, particularly by UCT and other groups, is suggesting that it's just causing the illicit economy in cigarettes to thrive, that normally law-abiding citizens who are desperate, who are in withdrawal, are going onto the streets to secure cigarettes that they're paying huge amounts for. So that's one aspect of the argument. And then, of course, major question marks about the medical evidence itself, a conjecture from FETA that in fact the minister has misrepresented some of the findings that she's used to base her argument that this is a health concern.
Karyn, we are running out of time. I need to fit this question in. Judge John Hlophe, the gross misconduct complaint against him is to be heard by the JSC in September. And this comes at the same time as we see that there's an affidavit by Judge Mushtaq Parker accusing Judge Hlophe of assault. What do we know of how this will impact on his standing as the Western Cape Judge President?
Well, essentially, the 2008 gross misconduct complaint against him has been hovering in the air for the last 2 years due to a lot of litigation, etc. For the last 2 years, it's been delayed because his lawyer, there was a disagreement between him and the Justice Department over his payment. That seems to be in a state of some kind of resolution, and that misconduct case, which was essentially linked to allegations that he tried to get judges in the Constitutional Court to swing a ruling in favor of Jacob Zuma, will now be heard in October. The JSC also saying that this very thorny debate, which concerns Judge Mushtaq Parker, the allegations and accusations and counter-accusations between the judge president and his deputy, including those allegations of assault, are, the investigation of that matter is at a very advanced stage. So the court, the JSC, very much taking on the chin this allegation or accusation that it's failed to deal with these complaints timeously. And it does seem that there is substantive movement in the resolution of these matters.
All right. Thank you so much for speaking to us, senior legal journalist Karyn Maughan. And for more analysis on the Gauteng High Court judgment that lockdown levels 3 and 4 are invalid and unconstitutional, we're speaking now to UCT constitutional expert Professor Richard Calland. A very good evening to you, and thank you so much for speaking to us, Professor Calland. What is your sense of the impact of this finding? We spoke to the ANC Deputy Secretary General Jessie Duarte earlier on, saying that she's very concerned about what this could mean. Do you share that concern?
Good evening, Spiso. Thank you for having me on. It's a judgment with potentially far-reaching impact. Certainly it puts a government that is already under great pressure, of course, because of the scale, depth and complexity of this pandemic and its crisis that it imposes on them and the country, under further pressure. They've said, the cabinet has said they're going to digest the judgment. We're all going to do that. I've read it, but I would want to read it more carefully. It's a very fresh judgment, as you know. But it's far-reaching because it essentially says that the regulations put forward by the government and imposed by the government under the Disaster Management Act, both for level 4 and level 3, are invalid. They're unconstitutional. They failed the test of rationality. Now, what's curious, and I haven't quite figured out if the judgment is wrong in this respect, what's curious, however, is that the main finding, as I say, is that the judge has said that there is no rational connection between the decision and the means by which the decision was reached, the decision-making process, in other words, and the end that is the objective of the regulations. And he goes through that process at times very carefully in the judgment in relation to some regulations, but in other cases in relation to other regulations, he appears to be actually straying out of that lane and basically saying, well, the decision itself just doesn't make sense. Now, that's not quite the legal test. So it may well be that there are good grounds for appeal in relation to this judgment. And then the second aspect, which is curious, is that having made that finding, the judge then gives the government 14 days to fix something that is actually not the problem here. He says that they must go back and consider the basis on which any of these regulations limit certain freedoms that are protected in the Bill of Rights. Now, we know that these regulations have to conform to the Bill of Rights unless through the limitations exercise that Section 36 provides, which is a balancing right, which enables rights to be limited in certain circumstances, unless that exercise has been proven to make sense, then, of course, there will be an infringement of the rights. Now, adding all that up and to get to the sort of bottom line here, Tabisa, I think that the government will want to take this on appeal and get it in front of the Constitutional Court, the highest court in the land, of course, as quickly as possible. And given the far-reaching implications and given the difficulty of this legal problem, I think it will be appropriate to have that Constitutional Court sit and consider this matter quickly and as soon as possible.
And what would it have to consider? Obviously, the ruling here saying that the regulations need to be redrafted, republished in consideration of the Bill of Rights. And government would argue that it was precisely reflecting on the Bill of Rights that it would have to come up with such a measure, protecting the health of all South Africans, limiting the number of cases of COVID-19 in South Africa as its duty as the state.
So I think what will concern the government here is that the government, as we all know, have put the public health considerations, the right to life, the duty to protect citizens from this pernicious pandemic. They've made that their number one strategic goal. And the regulations and the approach of government flow directly from that priority. What, of course, this judgment does is to unpick some of that. It says that at least in respect of some of the regulations, where I found the judgment more convincing than in relation to others, what the judge says is that the way those regulations have been decided on and the actual impact of the regulation itself does not meet the end objective, which is to delay the transmission rate, the infection rate of COVID-19. Now, I'm not sure exactly what evidence the government put before the court. Maybe the evidence was not clearly communicated. Maybe the government didn't make its case well enough. I don't know. One would have to look again at that. But I certainly think the government will be very anxious about this judgment. They will want to have a second crack at this. And I'm pretty certain that their legal advice would be, let's appeal this. Let's get the Constitutional Court to look at it quickly, because otherwise it's going to create a massive spanner in the works in terms of already very complicated governance conundrum for the government.
Professor Calland, there were some political pundits who had warned ahead of lockdown that we were always going to stray into this era, creating something of a security state by this national lockdown regulations that have been put in place. Do you think that that is what's also the bugbear, that people do feel that their rights have been taken away? Obviously, there would have been no time for consultation. Some have said we were facing the unknown of unknowns, so this was necessary action.
So in a situation like this, it's clear that the government response probably necessarily requires some limitation of normal freedoms. I think people would, in general, accept that as a starting point for this conversation. The question then, after a while, starts to be, are those restrictions justified? Do they meet the end goals? Are they effective? Are they working? Or are they, in fact, doing more harm than good? Those sorts of questions. And of course, as the lockdown went on and weeks went by, people became more restless and started to question the reasonableness of some of those restrictions. And of course, the government was having to work under great pressure. It itself has admitted that it will have made mistakes because this is uncharted territory. What's, I think, very important to recognise, whether this judgment is right or wrong, legally speaking, is that the rule of law, once again in South Africa, is...
UCT constitutional law expert and associate professor Richard Calland. Professor Calland, just please let me allow you to finish that train of thought. Unfortunately, we got cut for a moment there.
I'm sorry, yes. I was saying that what's important to note is that even though this is a crisis, it doesn't mean that normal rights are suspended. The Constitution is still the primary law of the land, and the rule of law must still prevail. And anything government does, even under these difficult and extreme conditions and crisis decision-making, must still stand up to the rule of law and tests of legality and rationality. I'm sure the government will find that inconvenient, but it will have to find a way of satisfying the court that it is doing everything it can do within the law.
All right, thank you so much for your time. UCT constitutional law expert and associate professor Richard Calland.